Good afternoon, and thank you to everyone for joining us on the webinar today. We'll give just a minute for everyone to trickle in from the waiting room before we get started. Good afternoon. Thank you for joining us on today's 2022 HR Manual Update webinar with Scott Moore, HR and Operations Consultant to the AAA and Principal of Moore EMS Consulting, LLC. Today's webinar is being recorded and will be sent out in our next Daily Digest newsletter. The slides for today's presentation were linked in the reminder email you received from Zoom earlier today, and I will drop them in the chat so you can download from there as well. If you have questions for Scott, please put them into the Q&A box. This is the double dialog box icon that is located near the chat box. It is my pleasure to welcome Scott Moore to present the 2022 HR Manual Updates. Scott?
Thanks, Sam. I appreciate it. And thank you to all of you for joining. Good afternoon to those of you and most of the country, and good morning for those of you over on the West Coast. I appreciate you joining me for this. It's really a little bit of a HR update as well as an update on what changed this year in the HR manual. As most of you know, for those of you who don't, my name is Scott Moore. I've been a longtime EMS guy. I've been an employment lawyer now for about 18 years and been working with the AAA for over 6 years. Always one of my favorite things to say to folks is trust a lawyer who tells you not to rely on what you're about to tell them. But the purpose of this program really is for information and educational purposes only. It's not to be considered legal advice. If you require legal advice, you should talk to a lawyer in your jurisdiction. What we're going to do today, and I don't know if we'll run the full hour, but that's famous last words. I tend to run over, and Sam usually is pinging me, telling me to wind it up. But we are going to just quickly talk about, there weren't a ton of changes this year, following 2021's manual, where there were a lot of changes and a lot of new sample forms, et cetera. This year was actually a little bit lighter in the changes that we made to the manual. I am going to give you just a few little HR updates, as well as a couple of heads up on things that are coming down the pipe for EMS employers. So, policy and procedure manuals, in all the years that I've been working in EMS, 31 some odd, plus the other 18 on the law side, I will say that it's interesting to me that, of course, most folks do have policy and procedure manuals. Most people don't tend to update them too regularly. They are pretty well aware that most of their folks, their employees, are not reading them, despite having them sign off on an attestation every single year. And often I joke when a supervisor will walk into my office and say, hey, we should have a policy on such and such. And I'll go, that's such a great idea. In fact, it's such a great idea. We've had that policy now for several years. So what we also know is our employees or our supervisors are also employees. And often those supervisors don't know the policies much better than, frankly, the staff does. One of the things that I will say is it is really important for you to update and revise your policy manual annually. And there's a lot of reasons for this. First and foremost, it is so that if and when you end up in an administrative hearing or in a lawsuit, or even just the important message that having a document that has a date on it that's pretty contemporaneous. In other words, if I'm looking at a policy manual that has a date from 2018 or 2016, has a few things in the world changed since 2016, it's important that you update this thing, revisit it annually, right? Because just the function of revisiting it allows or makes sure that you don't have information that's out of date, and as a result, putting the organization unnecessarily at risk. But more importantly, it doesn't let your employees, sort of put your employees in a position where they might be referring to information that is out of date. And so it is important that you are yearly going through this process. I also serve in a role with the Commission on the Accreditation of Ambulance Services. One of the things that those standards require are that you have a legal sign off every single year. And so I would suggest that that is something you should just make it a practice. In the organizations I've worked with, they have been pretty diligent about setting a calendar reminder to right around September, October, picking up that manual and assigning the group to go through and make sure that it's updated. One of the things that I should have mentioned on the last disclaimer slide is that is one of the new changes. One of the things I just realized I had missed in the prior versions of the HR manual was just a slight disclaimer that says, look, this manual is intended to be sort of for reference. It's not intended to be legal advice. So, and lastly, I say this to folks, you should have, when you update your manual, not only should you have folks sign off on an attestation at the time that they join your company, but anytime that manual is updated, you should have them sign an attestation. This includes your leadership. This includes everyone in your leadership, right up to the top, that they've read and are responsible for what's in that manual. The other thing that I do suggest folks do, and I think I've said this before, so forgive me if I'm repeating myself, is when you have employees sign any other document in the course of their employment, whether it be an individual policy that goes out, whether it be a job description or a performance review or a performance improvement plan or a corrective action, you should include a notice at the bottom that states that they are responsible to stay updated and have read your policy and procedure manual. All right, so what has changed this past year? One of the things that I wanted to let folks know, and this is something that is every year you should be revisiting. Most people, or many people, sign up for what is a poster service. So there are these groups that, by the way, once you end up on their mailing list, you will never get off of their mailing list. But you should know that there are posting changes every single year. This year is no exception. One in particular is the federal contractor minimum wage under the executive order. So understanding that there is a posting change if in fact you are a federal contractor. Additionally, there were 21 states that had minimum wage changes, either had them or will have them this year. And so you should also make sure that you update your posters. Many of the poster changes that came up this year were things including either changes to whistleblower protections or retaliation protections, or there were changes to some of the revised penalty levels that would be included in some of the enforcement actions. Lastly, there were some changes to, in many states, for pregnancy laws. And then again, just one of the things that I think if someone were to come to your workplace, and one of the first things that they're going to do are look for those postings. Now, a lot of people ask me, can these postings be electronic? And the answer is they can be electronic, in particular for those employees who never come to the workplace, but that doesn't excuse your obligation to also post them in the workplace itself. The links that you see here at the bottom and any link that you see in the presentation are active links. So when Sam sends out the PDF version tomorrow with the recording and any other information, you can go ahead and just follow the active link to any one of the underlying resources. So lots of posters. SHRM does a great webinar every year. JJ Keller does a great webinar every year where they walk through, it's an entire hour, 90 minutes on where they walk through every single poster change. Suffice it to say, you can either go ahead and watch that one, or you can just simply, if you haven't done it, the poster services are nice because what they will do is anytime there's a change, whether it be mid-year or any other time, they'll just send you a new updated poster, and they don't tend to be too unbelievably expensive, at least I don't think. So some of the changes that we had in this year's manual, certainly in the EEO policy, I did add just a practice note that folks need to remember that they're required to report if you are a federal contractor or you are a federal contractor with 50 or more employees, or any employer with 100 or more employees. You are required to file your EEO data. Now, that being said, one of the things that I want to make sure that I alert folks to was there was a recent OFCCP directive for those folks who are contractors, all right, and for those who are contractors, or for those, frankly, this should be something that you should have as part of, many states have passed pay equity laws, is there's a requirement in your EEO requirement to perform a pay equity audit. All right, so that is, in other words, what the OFCCP directive stated was that when OFCCP does audits of EEO plans, or goes through to look at the contractor to make sure that they are compliant, one of the things that they have the right to request is a copy of your pay equity audit. Now, often, or up until this, I had always suggested folks to engage their counsel when it came to doing pay equity audits. In other words, have their counsel oversee and direct that pay equity audit. Why? Because then it would become privileged and arguably excludable from discovery. This particular OFCCP directive came following a case that actually where they were successful in actually getting that pay equity audit excluded from discovery. However, in OFCCP's response, they essentially changed the rules to permit, or to say that this is a function of determining that you've been compliant. So pay equity is a huge developing area. It, many states, the state of Massachusetts passed a law quite some time ago regarding pay equity and the obligation. If you'd be amazed at how easily pay disparities can come up or can be perpetuated. So a perfect example of that is I think I'm going to hire individual A, and in my head I think I'm willing to pay individual A $18 an hour. Individual A walks in and says, I'm making $16 an hour at my current job, and I think, ooh, I was prepared to pay 18, but because they're making 16, I will pay them $16.50 or 17. That's how you could potentially perpetuate the discriminatory practices of another employer. So your best bet is to do a pay equity audit. This is something I don't do them myself. I will oversee them or assist with them. But what I'll say is this requires a multiple level regression analysis. This is a specialty, just like affirmative action plans tend to be. You will need someone to do multiple level regression analysis to be able to weed out those things that are permissible. But I strongly suggest that you get one done. So while that part wasn't per se put into the EEO policy, because that OFCCP thing just came down the other day, we'll be making the change to make sure that that's listed in there as well. I wanted to, while I am about as done with COVID as a human being can be, I wanted to quickly make sure that I provided a little bit of an update for you relative to COVID and some of the ADA protections. Now, this isn't specific to the handbook, but it's important that you are aware that the EEOC released some guidance back several months ago. I sent out an advisory to all AAA members that there is a condition associated with COVID that could qualify as a disability called long COVID. I think most folks are aware of it, or at least remember. This is individuals who either had pretty significant illness, but could also have had very mild illness, but then have persisting symptoms that last for months. And what they said was, you just need to be cognizant that those individuals may require that you go through that interactive process. All right. In other words, and it's just generally a good practice if someone's approaching you with a medical condition, that you go through the interactive process. It may or may not qualify as a disability. That's another issue, but just do yourself a favor, go through that interactive process, document that process, and determine, do you have an obligation? Are you able to accommodate that person or not? So just be conscious or cognizant of that. Now, on to immunization. I think I've done 160 reasonable accommodation meetings for folks relative to vaccination over the last 75 days. Mind you, I only ever did 3 reasonable accommodations prior to 75 days ago in 18 years. But I've done a whole bunch of them lately. And one of the things that you should know is that one, the CMS ETS mandatory vaccination requirement is in effect and applies to those covered healthcare facilities. That many ambulance providers, while not directly covered, are in fact covered or brought in because they are a contractor to that organization. I have heard from a lot of folks around the country that they are starting to get notified by those covered healthcare facilities requesting information, either having them fill out a log, which details out all of their employees' shots and who's got an exemption and who doesn't. I did draft a sample response letter that you could furnish to a facility that will be included when Sam sends that stuff out tomorrow. It is just a letter that says essentially, hey, we know about the rule. We understand that you're required, and we understand that we're required because we're a contractor for you. We are attesting, one, we've instituted this mandatory policy, and we're attesting that anybody who would be covered by this is in fact vaccinated or has a protected medical or religious accommodation. I would not actually share the nature of those. I mean, technically, you could share the information relative to their vaccination status, but truthfully, if I were those facilities, I would not per se want that information. An attestation, in my book, would be a lot better. Now, recognize though, as a contracted provider, you should check your facility contract, especially for your indemnification language, right? If you are then telling them, hey, we know what your obligations are under this rule, and we're attesting that our people meet that, you want to make sure, to the extent that there may be some liability that they bear that you that is either covered in your indemnification clause, or just recognize that you might have that risk. Your facilities are going to be checking for compliance with that with hopes. Some facilities have sent out a letter very similar to this. I know, talking with Steve Worth, he showed a copy of one to me that was very similar. But just recognize this form is out there. My position is share as little information as is necessary to satisfy what your facility is requesting. One thing that I did want to alert folks of, and we just sent out a member advisory just a couple of days ago. I think it was actually yesterday or the day before. OSHA has announced that they are going to partially reopen the notice and comment, or the rulemaking process, for the permanent standard for protecting healthcare employees in the workplace. So as you recall, there were 2 emergency temporary standards that were issued. One called the healthcare ETS that was issued back in June of 21. That did not require vaccination. That required a whole bunch of other stuff, but did not require vaccination. Then there was the other mandatory vaccination or testing ETS that was attempted to be issued and then got overturned by the Supreme Court. Just be clear, OSHA is not in this permanent standard. So what they're really reopening this on is on that June healthcare ETS that did not mandate vaccination. They're reopening, they are not proposing mandatory vaccination for healthcare workers. All right, so just to be clear, what they are doing though is seeking additional public comment, because a lot of what we gave in feedback to OSHA and the other agencies there's too much contradictory or too much inconsistent guidance out there from the various agencies. And in some instances, OSHA's regulations or emergency temporary standards were not consistent with, let's say, for example, the CDC guidance. So they are looking for additional comment. There will be a public hearing, I think, on April 26th, April 27th. If you are intended to appear on April 27th, you need to file a notice, I think, within 30 days from now. But if you also are interested in submitting a comment, you can do so by following, it's right on these slides here. You can follow that link and that'll take you to the comment place. What I like about what they're seeking additional information on is it looks like they're looking to maybe temper some of the OSHA requirements some of the requirements in the permanent, or what would be a permanent rule. So they are looking specifically to tie looking for people's feelings on whether they should tie the rules to, for example, the CDC guidance relative to mask wearing. That would permit the rule to modify based upon CDC guidance so that there wasn't this requirement, let's say, for mandatory masking for unvaccinated people forever. It would allow it to tie to the CDC so that when the CDC said we're through the woods, you don't have to mask anymore, that would allow OSHA's regulation to modify or be more agile with what the current guidance is. They're also seeking additional information on, to what degree they should encourage or require employer support of vaccination or subsequent booster shots. This, again, as you recall, there were requirements for up to 4 hours of paid leave for employees to get vaccinated or to seek boosters. They're just seeking additional information on that. In looking through the 22, 23 pages of their request for additional information, all of it looks like it's heading in the right direction. And I say that from the perspective of, I think employers have had enough. I know I sure have. And it looks like they're looking to make what will be a more realistic and more tempered healthcare standard that will protect employees, but also maybe quiet down some of the polarization that's occurred. So more to come on that. We'll keep you posted. If you didn't see the member advisory that went out earlier this week, please go ahead, look to your daily digest, and you will find it, or you can just send an email to hello@ambulance.org and we will get you a copy. Workplace violence. I did make a modification to, or actually what I'd say is, one of the strong suggestions, and OSHA has been posting stuff on their website about conducting workplace hazards. And one of the areas that they have expressed as a concern, given sort of some of the social unrest that we've seen and the incidents, frankly, the numerous incidents of workplace violence that we've seen, strongly suggest that you establish a policy relative to weapons. Now, we have one, and recognize, I understand that in some states there are permissions that other states don't provide. So your policy should address your position on weapons inside the workplace, but it also should address the position on weapons in a parking lot. Recognize that, as I said, there are several states that have state laws that say or protect an employee's right to maintain a firearm secured in the parking lot. Here's what I'll say. I think it's important that your organization take a position. It certainly cannot be contrary to law. The fact of the matter is, if someone is looking to do harm in your organization, whether there's a law that said they can have a firearm locked or secured in their parking lot is probably not going to stop them. But what I would say is, having a policy goes to what degree you as an employer not only try to assess the risk of workplace violence, and to what extent you try to mitigate that risk to protect your employees. I will tell you, I think it is far more common now that people have their offices locked down so that they cannot just walk in at any time. If you have not done a risk assessment, most people are looking for trip hazards. They're looking for, broken switch plates. They're looking for, markings on stairs, etc. Probably also even still looking for some of the respiratory protections. I would strongly suggest you either talk with your local law enforcement professionals, because they are your partners, and have them come in and do a walkthrough with you, document that walkthrough. They might be able to identify areas of potential risk for you. Again, nobody wants workplace violence for sure, but you also want to make sure that to the extent possible, you can do that assessment, document that assessment, and then make the changes necessary to provide protection to your staff. For example, punch locks are great. However, if you don't change the punch lock after, let's say, you have an employee terminate, that certainly isn't going to make it. The likelihood that a stranger walks in off the street is probably far less than the likelihood that an employee might walk in the street. The other thing that I would say is, in many states, there is a requirement that you have a posting at any entrance. So just confirm with your state law. Again, be clear on your position about people entering your property, your company property, and or your company, your actual physical location relative. If you haven't seen it, those 3 links at the bottom are different workplace violence assessment tools. They're just resources. I'll say I looked at them. They looked relatively comprehensive, but what I would say is certainly do something rather than doing nothing. Document that assessment. Again, if you have an event at your organization, or if for whatever reason OSHA knocks on your door, which I don't think they will do. Generally, OSHA will not just pop over unless there's been a complaint. You want to be able to point to the fact that you've done a workplace hazard and risk assessment. That hazard and risk assessment should be comprehensive, but also should include, for certain, should include the risk of workplace violence. Now, I did add a practice note in the domestic violence policy about how many states now have in fact passed rules or laws relative to furnishing either workplace protections and or paid time off or unpaid time off from work for employees who are the victims of domestic violence, and to attend to those related issues, whether it be court or other proceedings. So I added a practice note just to make sure that folks recognize that there have been some pretty significant changes around the country. More and more folks are, in fact, or more states are, in fact, adding domestic violence protections. The leave, the protections from discrimination, as well as, in some states, an obligation to reasonably accommodate those folks, much in the way you would for religious or medical issues. So I'm like way ahead of schedule, which Sam thinks I'm an entirely different human being because normally I'm running way over. Criminal history inquiries or ban the box. I brought this up nearly every single year and in almost every presentation relative to updates. Just so you know, there was recent affirmation that if you are a federal contractor, you may no longer have a box or a inquiry on your application that inquires about someone's criminal history. All right. The idea here, that's New England for you. The idea here is that in an individual, if they, let's say, had a criminal offense 20 years earlier when they were a teenager, but an adult that appeared on their record, would that individual be less likely to get an interview or have an opportunity to explain what happened, or might they just be excluded as a function of having checked that off? As a result, many states, and as you can see here, those are highlighted there in the dark blue, have, and states and or cities have laws that prohibit having that on the application, in some instances, making an inquiry prior to an offer or a valid job offer. So make sure you understand that really nearly half of the states in the country now either pre-offer. My suggestion is you're going to run a criminal background history on these individuals anyways. So I probably wouldn't bring the issue up until you've done your criminal history background check. And if there is something that's potentially problematic, then you would go through the process of giving the opportunity for that individual to see what it was that came up on the report, give them an opportunity to dispute and or correct that report. But there really isn't, and I know I've talked with some, like in some states where, hey, EMS employers have a right to ask that question. That's wonderful. What I will tell you is if you're an EMS employer in a state where they permit that question, but you're also a federal contractor, you need to recognize that you can't ask the question. The other thing is, while there may be a law that protects you for asking that question, that does not protect you from what's a disparate impact claim, which is, hi, I have a policy which on its face is neutral, but its impact is discriminatory. So it's important you recognize, again, you're going to run a criminal background on this person. Why would you not get through that process, honestly? And you certainly aren't looking to exclude individuals who 20 or 25 years ago may have done something nonsense. I'm not suggesting that I ever have or that any of you have, but what I'd say is give them an opportunity to get in. Folks have the right to rehabilitate themselves, and questions like that on applications really don't ever give someone a fair chance. So remove that question from your application. All right, so paid time off. Many states have implemented either paid sick time or paid family medical leave, or both. So it is, and by the way, a ton of municipalities have as well. So it's not just enough. And this is one of the challenges we have in HR. When Brian gets to do Medicare law is the same no matter what state you're in. The problem with HR or employment law is that it not only is there the federal law, there are the state laws, and then there are local laws. So it's important that you do the diligence to make sure that you have checked all of those areas. So many have paid sick time, many have paid family medical leave. 6 of them are actively in place. There are some that are still in the batter's box waiting to go. So just make sure, if you aren't aware of it, you probably would have heard, and in many of the states where there's also a requirement that you're reporting, that you're doing some filing with the state so that you can get that, so that you're making your appropriate payments. Because in many of the states that have at least, let's say, for example, paid family medical leave, the pay structure is very similar to, for example, almost like an unemployment payment. In many of the states that have paid sick time, that is generally, for each hour, for every 30 hours or 40 hours an employee works, they're earning 1 hour paid sick time, and that's generally funded by the employer. So, but if you haven't seen the trend, what I will tell you is there is a trend. It is coming, so be prepared for that. Now, I did add a practice note about cannabis and the lawful use of cannabis. I added it last year, but then I added additional. I also just heard, thanks to our good friends in West Virginia, about a variant of cannabis called Delta 8, which apparently is not like high enough. It's kind of like a CBD oil. One of the things that I will say, I get this question a lot, is what do we do? We're a federal contractor, so we have to maintain a drug-free workplace. For those of you who attended the webinar that Margaret Keaveney and I did, Margaret's position was, well, technically what the Drug-Free Workplace Act says is that someone can't be under the influence if they work for a federal contractor while at work. And just so you know, many states have passed protections for an individual's lawful off-duty use of cannabis, including preventing discrimination on the basis of their lawful off-duty use of cannabis. This has led EMS employers into a very difficult corner. And the challenge is, how do we know, because there is no way currently to determine or to test to determine if someone is currently under the influence of cannabis. And when I added a note last year, and I believe it's, hopefully I'll get this right, if you're using CBD oil, and that CBD oil, because it is not regulated by the FDA, what is on the package may or may not be correct. So the concentration of THC may or may not be correct. I'm not suggesting that that the dispensaries are not being honest. The only thing I will say is, if we could build homeless shelters as quickly as we could build cannabis dispensaries, everyone would have a place to go home to. In any event, what I would say is there are more cannabis billboards than there are lawyer billboards, except for people are, I guess, happy to see the cannabis billboards. In any event, what I would say is make sure that you understand if there are protections. A lot of folks have asked me what to do, and part of me has said, you may want to consider removing the testing for cannabis or THC from your their drug panel. The other option would be to talk with your medical review officer, and that is the individual or the physician or healthcare provider who validates a test that comes back as non-negative. A non-negative test is, let's say, for example, someone's taking Adderall or some other amphetamine for ADHD. If that person takes a drug test, it is going to pop positive for an amphetamine. In that instance, the medical review officer from the lab will generally call that employee, confirm that in fact that medication is prescribed and that it's being appropriately used. They may even call the prescribing physician. In that instance, then what you will get back as an employer will be a negative result. All right. You don't want to know what medications your employees are legally taking, provided they're not impairing them at work. You can consider, and truthfully, this is a new idea. I'm not sure how many MROs are doing this, but you can consider seeing if the MRO will go through that process with them. At the end of the day, your best defense, your absolute best defense, is to make sure that all of your folks, all of your supervisors are trained and educated on how to spot impairment, because impairment, again, is the best way to, is the best impetus for giving someone a test. If somebody, in fact, is impaired at work for whatever reason, that is not protected no matter what. And in every one of those state laws, it is not protected. That being said, of course, still, my clients, I'm still advising, listen, it's okay if you're a federal contractor to say that you have a drug-free workplace. The challenge runs into, when you drug test, what then do you do? I don't have a great answer for that now, but I would say just make sure that you should talk with your local attorney. And again, really, if you stick with impairment, then you should be okay. All right. I did add a form since last year. One of the things that we find often occurs is people depart the organization either because we've asked them to leave, which is rare these days, or they have decided to leave. I did add a form, just a sample form on a termination checklist. I am a big fan of checklists because, again, you want to make sure that a ball doesn't get dropped somewhere throughout the process, whether it's onboarding people, orientations, whether it's field training, or in this, whether it's benefits administration, any of those, family medical leave, you should have checklists to make sure that it's handled appropriately. And just for the record, when a regulatory agency comes in to visit you and you can point to, here's how we do things, here's how we make sure that nothing falls through the cracks, it does lower their index of suspicion. It always did for me when I worked at the USDOL. It does lower their index of suspicion that you're just winging it. So I added a sample termination checklist. If you see, as with any of the forms, if you see something in the form that you think, geez, I've seen this added or this differently worded, reach out, please let me know. Certainly we'll take that under advisement. And this is an idea of the rising tide raises all ships. So the goal being that you ensure that consistent process, that you don't have somebody who left the organization, but we never shut off their internet or their email or electronic access. That doesn't get missed. We didn't forget to collect back any equipment that we had. I think this is pretty standard, but I wanted to at least provide one that, to the extent possible, really covers all of the bases. So workplace safety, I did add a practice note that several laws were passed back in early 2020 and 21 that essentially made COVID, a positive COVID test for a healthcare worker or an EMS employee, a presumptively work related. What I will say is some of those I know expire in 2023. What I would suggest for you is that if you have an employee who, if you are in a state where there is no presumptive COVID diagnosis, you have an obligation still to conduct an investigation, just like you would for any other illness or injury that the employee is citing is work-related. You would have an obligation to conduct a reasonable investigation. And so, for example, if that employee comes down with COVID, but they haven't been at work in 2 weeks, but they've been out on vacation in Aruba, I think it's fair for you to document that it's highly unlikely that this employee caught COVID at work. Again, just be aware that in some instances it is presumptively work-related. There are still a whole ton. When I looked 2-3 days ago, there are a whole ton of states that still have pending bills right now for this issue. Whether they will just die in committee, I don't know, but we will. I just wanted to make sure that you were aware of it. One of the things that I put something out a few weeks back about is just recognize that while the specific data has not been released yet, OSHA announced that they had a 249% increase in reported illnesses and injuries in healthcare settings in the 2020 year. Not surprising, right? It was during the peak of the pandemic. So what I would suggest is keep in mind that we are electronically reporting our 300A log information to OSHA. Now, what OSHA says is that data is going to be made public, and that data in its summary form will be made public as a way of hopefully sunshine being the best disinfectant, that when people's information is public, it won't be individual employees' information, but the data relative to employers and how safe things are, that's going to be made public. One of the things that I would say, again, I say it in cost collection, is data is like trash. If you're going to collect it, you sure as heck better know what people are going to do with it. So recognize, if OSHA is collecting specific data from you as an employer about your illnesses and injury, rather than just in the old days where you posted it from February 1st through April 30th, you need to know that that data is going to be used at some point for enforcement. We used to, when I worked at the United States Department of Labor, we used to do, or we had a process by which we did, they did something that was called targeting runs. And targeting runs were when they were looking for a specific issue, they would then run the algorithm through the 5,500 forms that were filed. In any 5,500 form that kicked that out, that was going to be an investigation. Recognize that if your organization has an unusual number, or you are 1 or 2 standard deviations outside of the mean, or whatever it is that they're searching for, you can probably count on getting a phone call or getting a letter sent to you. Health and social assistance accounted for more, just so you know, more injuries than any other industry that reported. One thing that I wanted to note, and I think this is an important element, we did see an increase in overall injuries because of fatigue in general. In other words, and I say this anecdotally because we haven't seen the individual information yet, but what I'm hearing from many, many employers around the country are, our folks are tired, and as a result, they're making, or they're getting injured in ways that they feel like they likely would not have been. Do not ignore that. Again, you should be encouraging near miss reporting. In particular, you should be encouraging near miss reporting because that is a gold mine of an opportunity of where you can prevent your next injury and hopefully your next career-ending injury. So be sure to be encouraging near misses, ensure to be doing a root cause analysis on any of those injuries that you have, but just be aware, 249% increase in illnesses and injuries, I can promise you that that is going to result in OSHA visiting more EMS employers. The top cited violations this past year were respiratory protection and bloodborne pathogens. All right, again, it's important that folks understand the top cited violations were respiratory protection and bloodborne pathogens. In many instances, that's folks not having a written respiratory protection plan, and probably the number one reason was failure to provide fit testing or be able to provide proof of fit testing. Now, OSHA inspections, while last year was lower than we saw in 2019, recognize that it was significantly higher than it was in 2020. 2020, OSHA generally was not going into workplaces unless they absolutely had to. Recognize or understand, please, that they have put out an updated field guide for their investigators, and they are now encouraging that investigators get back out into the field. We are, again, 249% increase in injuries. I don't know where EMS sits in that as compared to other healthcare providers. As soon as that data is available, we'll make sure that we get that out there. But just recognize, I think it's a strong likelihood that we are going to see, they've issued a lot of national emphasis enforcement programs. And so recognize that that's probably coming down the pike. There's one thing that I want to discuss, and people are going to probably roll their eyes at me when I do this, but I want to talk about masks and beards. Not this kind of mask and beard, this kind of mask and beard. It is impossible. And I've had people tell me, oh, no, I made a seal with an N95 mask with this beard. And what I will tell you is that this doesn't even pass the smell test, sort of ironically, which is what we generally use in an N95. Masks and beard, not this kind. Although this kind would be really cool if all of our folks wore those. OSHA investigators, right? They live among us and they drive past our people in ambulances and out on the scene of calls. And they, by the way, this is a great indication. If you're asking for someone to bebop by your place, recognize, just that you know, that anybody walking around that looks like this, half of this, or even 1/4 of this is not making a quality, unless you have a quantitative testing system, which is where you actually puncture the mask and there's a machine that actually tests if the mask is making a seal. I would suggest that you have to, despite how much people like beards and how cool they look, the fact of the matter is, it is leaving your folks at risk. And if OSHA comes in, they will say that you are not maintaining a standard. Just so we're clear, would you allow your folks not to choose not to wear seatbelts, to start sticking IV needles into the bench seat again, or to recap needles? You would not. This is no different than that. I'll get off my soapbox. All right, social media and standards of conduct. Just wanted to make sure that there are a few states out there that have provided some protections from a perspective, or at least notifications to employees if you are providing or doing any kind of surveillance, electronic surveillance in particular. Now, if you have cameras, which many folks do, they're using those Ring cameras, etc., recognize that many of those Ring cameras actually pick up audio. If you're in my state of Massachusetts, you need to know that you are not, that violates the wiretapping statute. You are not permitted to capture somebody's audio unless they are aware that you are doing so. So if you are using electronic surveillance, you should have postings up. Some states, more recently, several of them have passed laws that say you must. If you are using computer monitoring or surveillance in some states, you must notify employees that you are doing so. Just be aware of that. It requires notice, requires a signed acknowledgement, and then again, also making sure that you secure the information that you might be surveilling as well. All right, cybercrime is a major issue. All right, minimum wage. There have been a whole bunch of states, 21 states, that, as I said at the beginning of the program, and we're almost done, by the way. There have been 21 states that had a minimum wage increase or will have a minimum wage increase, as you can see up here. This coming year, for some reason, a few have chosen to, make that minimum wage change in May or July. That minimum wage increase, if you live in one of these states and you are unaware, generally most of our people are over minimum wage. Just recognize there is a compression that occurs when the minimum wage comes up. And so it's important that you recognize, again, I know there's a ton of reports out there right now about wages and where they are in comparison to inflation, and why people do not functionally feel like they're making more money because inflation has overcome whatever wage increase that a lot of folks have given. That being said, just be aware that you need a new posting, not only that, and also make sure that you're not inadvertently below or failed to realize that that minimum wage changes occurred. Also for those federal contractors, the minimum wage has modified as well. All right, I am going to try and bring up that chat to see if we have any questions in there. Let's see, in mass under MART and GAT, you can tell that I'm tongue-tied today. GATRA HST contracts, marijuana is listed as something that needs to be tested for. Okay, I get that. Marijuana is something that needs to be tested for. That's great. You can, if you have a specific law that says you must test for it, then you should test for it. All right, that's perfectly fine. What I would still say, again, is make sure, to the extent, if there's a requirement you do it, you should of course do it. But don't just presume necessarily that you are going to be protected, like in New Jersey, where there is a law that prevents the discrimination against people who are legally using cannabis. Just want to make sure that people are aware of that. So Andrew, thanks for that question. Again, I by no means am, I'm not necessarily advocating for cannabis use at all. But what I would say is just recognize that you're probably as at risk for alcohol use or other over-the-counter substances as you are for marijuana use. I will say, I don't think I can drive down the street without getting a waft of it, which and certainly can't drive down the highway without seeing a dispensary billboard. But what I want to make sure that people know are there have been a move towards protecting people who are legally using substances in EMS. Generally, we have to be really, really cautious. But again, if you think it's the rule that's stopping them from doing it, I got news for you. You're probably off. Any other, Sam? I don't know if I'm not seeing any other questions. So I know Sam has included the not only the slides in PDF form with the active link, but also that additional sample form that we added. The other sample form, the termination checklist, is already in the HR handbook. If you have the HR, if you are a AAA member, those handbooks are free and included. And if and if you are not a member, I don't know what you're waiting for. Certainly everyone's doing, all the cool kids are doing it. You should be a member. So that being said, I don't know if we have anything else. I don't see any other questions in the chat. Samantha, do you see any?
I do not see any other questions.
All right, great. Well, with that, I want to say thank you to everyone. I know it has been one heck of a year for folks, and again, and there doesn't seem to be any sign of it stopping. It just keeps going on and on and on. But what I would say is, if you have questions, hello@ambulance.org, that gets sent into our ticketing system, and it doesn't have to just be HR questions. It could be any question. There's a lot going on right now in the AAA. This is probably the busiest I've seen this team in, I think, God, I've got to be 17 years history of working with the AAA informally, and then 6 years of working with them formally. This is probably the best team we've ever had, and they are rocking and rolling all the time. So what I would say is, if you have questions, you can either reach out through the hello@ambulance.org, or my information is up there on the screen. I can't thank you enough for all the work that you're doing. Really, truly appreciate it. And we will see you on the next webinar. I'll pass it back to Sam to close us out. Sam, any closing remarks?
Thank you, everyone, for spending your afternoon with us. And as I mentioned before, the recording of this webinar will be available in the next Daily Digest. Thank you.